Hello, my name is Olurotimi Osha. I like talking about American presidents. I'm continuing with my discussion on the deprivation of rights and color of law violations under the malicious prosecution that I've been suffering in Montgomery County Circuit Court in Maryland. Of course, it's intended to obstruct justice. I've done videos talking about how I was swatted through a false crisis score hoax on May 16, 2023 in my home. And I was assaulted by about 40 police officers, Montgomery County police officers, who raided me and shot me in my head. So it's a case that has no merit. It's just created as a malicious prosecution. It's a futile prosecution intended to prevent the prosecution of the police, and it was to obstruct justice in other investigations. As of May 16, 2023, I was actually an auditor holding a top secret TSSCI clearance, working in the Department of the Navy, and I reported the public corruption, misconduct of senior executives, and this was under investigation, senior leaders. There was probably some kind of retaliation, but in any event, I've been the police officers who assaulted me, shot me in the head, removed me naked, and dehumanized me. Now filed false charges against me, and the state attorney in Montgomery County has continued with the malicious prosecution. Right, but I have a right to defense. Right, a right to defend myself at courts. It's been 3 years now, and I've done videos explaining all the shenanigans of the courts and the procedural unfairness perpetrated by the Judge James Bonifant, who's the circuit administrative judge in Montgomery County, Maryland. Um, so on February the 2nd, 2026, just last week, a few days ago, last week, I requested, um, you know, another attorney, right? So my public defender was struck by Judge James Bonifant. Her parents were struck. That means um, they removed her as counsel. And I requested another attorney, but Judge Bonifant was now going to sort of place me under duress or coerce me and state that, well, that if I don't appear at my trial, which is tomorrow, February the 9th, 2026, with another counsel, right? He said I could either go pro se. I said, I'm not going to go pro se. I'm not waiving my right. I want another counsel. But he was asking me to get a private attorney, but I'm currently indigent, right? So I was appealing to the Office of the Public Defender. He said if I appear without an attorney, then he's going to take it as a waiver, right? He's going to give instructions that the judge should take it as a waiver of my right to counsel, and I have not done that. So he asked me to. So he what he tried to do was also again inveigle, like he tried to deceive me, use deception, and this is something he's been doing. He tried to use deception and make a specious argument, saying that even though I asserted my Sixth Amendment constitutional right to effective counsel, right? It's an absolute right to effective counsel. He told me to go and read a case that says, no, I don't have a constitutional right to have a counsel. If I fire an attorney who has their conduct, they've engaged in attorney misconduct, or they're sabotaging my case, and just 7 days to trial, they're basically trying to sell me out to the state attorney, and they've been ineffective, they've been incompetent. So he found a meritorious basis for me to fire my attorney, and so he asked me to go and read this case, Dykes versus State of Maryland, and it's a 2014 case. So I read it. It's a very interesting case. So I'm going to break this video up into two discussions. I'm going to discuss the case. It's very interesting because um, it affirms what it is I was saying. So I'm just going to discuss the case first, and then in a subsequent video, I'm going to give my sort of disquisition regarding the misconduct of Judge James Bonifant with respect to depriving me of my right to effective counsel, right? And that's a Sixth Amendment right. So the case of Dykes versus the state of Maryland, let me just state that it brings out some very important things. It refers to several cases, and it refers to a rule, a Maryland rule. It's 4215E with regard to representation of counsel, and it says that a defendant can only they can only waive their right to counsel, right? Because it's an absolute right, it's protected, it's constitutional, Sixth Amendment, right? In a criminal case, right? They can only waive it if it's done knowingly and voluntarily, and there's steps to make sure that it's done knowingly and voluntarily. And it, because defendants still have a right to self-representation, so it referred to some cases as well. For instance, a case like there's Ferretta versus California of 1975, which says because it is the defendant that bears the responsibility, for the consequences of conviction, and so they have a right to they can't be forced, they can't be forced to accept a counsel, right? They can't be forced to accept a certain counsel, and they also have a right to self-representation, and also they have a right to decide if it is, their particular case, if having counsel is to their advantage, that's a defendant's right, because they're the ones who bear the responsibility of the consequences of conviction. And also, there's also another case that's also supported in Dykes, and that's it emphasizes it says that because one's accused of a crime, it's still necessary that a defendant affirms their dignity and their autonomy, and this is affirmed in their right to self-representation, their right to make their decisions, their right to dispute with the strategy of counsel, and that's in the case is in Parren versus State, right? In Parren versus State. So that's the dignity. It affirms the dignity and the autonomy of the accused, right? That's part of common law, and also it states that a defendant, right, with respect to waiving their rights, that it equates, that if a defendant decides that they're going to assert their right to self-representation, right, they have to do it clearly and unequivocally, right, and that can be equated as it can be represented as their waiver of their right to counsel, right? But it has to be done clearly and unequivocally. That's what Pinckney versus State says, right? Pinckney versus State says that the defendant can waive their right to counsel if they assert their right to self-representation clearly and unequivocally, right? If they're saying, well, they're going to represent themselves, then clearly and unequivocally, then it could be interpreted as a waiver of their right to counsel, right? So it says that, but it then it now puts an onus on the court, on the judge, the court, that, the court first of all has to take rigorous steps, right, to ascertain that there's a Maryland rule 4215E that asserts that a defendant can only waive their right to counsel if it's done knowingly and voluntarily, and it gives certain steps, and it says that it allows certain procedures that that the judge the judge would first of all evaluate, would interview, right, discuss with the defendant and find out if their desire to fire their present counsel. So this case had to do with someone who already had counsel, and they were firing, from the Office of Public Defender, and they were firing their attorneys because they were dissatisfied. And I'm going to narrate after I just outline the main, the salient points from the case Dykes versus State of Maryland. So this guy was, he was represented by the Office of Public Defender, but he was saying that he was firing his attorneys because he said he didn't trust them and they were doing things that were outright unethical, attorney misconduct. And so the judge would interview him, have a disquisition on why he wanted to fire counsel, and he found his reasons to be meritorious. But this guy was indigent, and he had no money, he had no means to get counsel. And he always stated that while he didn't want a certain attorney, he still wanted someone to represent him, right? But he had no money. But eventually, because the judges were saying, well, he doesn't have an unlimited access to attorneys if he keeps firing his attorneys, right? And so if he doesn't accept this, certain attorney and whatever, that he's going to have to go pro se, right? And eventually when he goes pro se, he's convicted. And eventually he files an appeal. So it's now at a higher court that's appellate level, and they're reviewing his conviction. So eventually, the court decided, right, on appeal that the court has an inherent authority to appoint counsel, right, where it's an indigent defendant, and the Office of the Public Defender is unable or unwilling to represent the indigent. That's he has no money there, so that's the indigent defendant, and it finds that the courts found that the defendant had a meritorious reason to fire the attorney, right? Meritorious meaning that it has a rational, justifiable reason. It's not just subterfuge or to delay the case or just tricks, but it's something that's reasonable, and it will help his case. In this case, the defendant was saying that, well, the public defenders were fabricating evidence. They were lying. He didn't trust them, and so the judge who struck counsel. That's what you say when, that's the legal term, when the judge agrees to have a defendant or fire their attorney. So they say they strike their appearance, or strike the appearance of counsel. And so the judge found his reason to be meritorious and allowed him to fire his attorney. So on appeal, the opinion was that even though Dykes had fired his attorney, and the fact that the judge was just saying, well, if he refuses to have this attorney, his public defender represent him, he can't have any other public defender. That's what the Office of the Public Defender was telling him, right? They told him that if he fires a certain public defender, he's firing the whole office. And I see that's a practice, because that's what they were telling me as well when I started using the Office of the Public Defender. So it's like you have a public defender who's sabotaging your case. They're ineffective. They're not doing their job. Everything they're doing it manifests attorney misconduct, right? For instance, they don't communicate with you. They haven't prepared evidence. They're trying to hide evidence. They're trying to they haven't even subpoenaed witnesses. They have not brought it to the court's attention that the state actually has fabricated evidence. They use false witnesses. So they fail to file motions to dismiss. They fail to file motions to compel discovery. There's defective discovery, like in my case. So they haven't done any of that. So they're basically sabotaging your case. They're selling you out to the state attorney, right? And this is what this guy is doing. So the fact that a judge, one says, well, they don't want a public defender that's going to sabotage them, and then the public defender's office says, well, if you fire this public defender, you're firing the whole office, right? That was the situation. So the judge now forces this guy to represent himself pro se, and he loses, right? Because he didn't have money to get a private attorney on his own. The judge was referring him to go back into the public defender's office, but the judge didn't acknowledge that he has an inherent authority, right, to actually appoint counsel for the defendant, an indigent defendant, because this man Dykes, he was actually indigent. And so the court found, they reversed his conviction, saying that, well, he had that the court had failed to use its inherent authority to appoint counsel for an indigent defendant, because Dykes had not, knowingly and voluntarily, renounced, his rights to counsel. He had not knowingly and voluntarily renounced his rights to counsel. And that's what that is, so you have an absolute right to effective counsel, right? And that's what I was insisting with Judge Bonifant. However, he was trying to use deception to tell me that, well, if I don't accept this public defender who's trying to sell out my case, who's not prepared just a week to go, who's trying to hide evidence, who's trying to do all sorts of things, who's ineffective, who's all she focused on for 8 months, and before her, the other attorneys they focused on for several months was to try and coerce me to accept an unfavorable plea bargain that would end up, that would not prove that I am not guilty. And I've said, no, I'm not guilty. I'm not accepting any plea bargain. This is a malicious prosecution. It should not have been brought. The people, it's a perversion of justice. It's adding insult to injury. The people who came to my home based on a swatting that they organized, they manufactured, injured me, almost killed me, dehumanized me, and removed me naked from my home, dumping me in a hospital naked in handcuffs, recording me like pornography. Actually, it's a federal offense. It's a human rights violation. They recorded me nude, exposed me to the public naked in a hospital, and they spread fabrication saying I was a homeless psychotic. They had spread disinformation in my home. And she wants to hide this evidence, to aid them. And then they now lied that I assaulted them. The people who have permanent scars, you see, these are scarring from the stitches. My nerves are dead permanently. They cause permanent nerve damage. It's another reason I keep doing these videos, to make sure my brain things are intact, right? And they've caused all these damages to me, dehumanized me for 3 years. And she's trying to hide the evidence, to add insult to injury. The people who almost killed me, who injured me, they claimed they were the victims of an assault by me. Until today, they haven't provided a bill of particulars showing how I assaulted them, right? And she wants us to walk into court, right? That's ineffectiveness of counsel. I have a right to change counsel. And so she did fire, counsel. He allowed me to fire them. But he was saying that, the judge was trying to coerce me, that, well, I can't get another attorney, which is not the case. That's not what Dykes versus Maryland says. The court has an inherent authority to appoint me effective counsel, to appoint me counsel. So let me quickly narrate what happened in Dykes, and then I will do another video just discussing, my opinion of, Judge Bonifant's conduct in his deprivation of my right to, my absolute right to the effectiveness of counsel, and how he's controlled the Office of the Public Defender and previous attorneys I've had. He's controlled them to work to sabotage my case, and just to protect the to cover up the misconduct of the police and maybe and to obstruct justice, And only when the FBI or the Department of Justice, when a proper investigation of the misconduct of Judge Bonifant is done, then one will know his real motives, why he's perverting the cause of justice, why he's engaged in procedural unfairness, why he's used bias and he's been very one-sided, and why he's been sabotaging me, why he's been acting, he's refused, he's denied me my natural justice, he's denied my right to be heard, again. That's, Audi alterum partem, the right to hear the other side. My side hasn't been heard. Only this one side that fabricated evidence. They've lied, and I haven't had the chance to dispute, present evidence. My attorney, the public defender, they don't want me to present evidence to defend me in court, and my trial is tomorrow, right? Judge Bonifant clearly has a bias, and he's not recused himself. I have a right to impartial jury. My public defender did not file for a change of venue. Again, that's in violation of, the natural justice principle. This one's nemo judex, nemo judex in causa sua. So now let me quickly narrate what happened in Dykes versus State of Maryland. So the thing is, so Dykes, he was arrested for, this was a case regarding burglary, theft, and things like that. He got his DNA, he was arrested, and things like that. So he was represented by the Office of Public Defender. And the guy admitted that he wasn't intelligent, but he was firm. This guy was firm, and that was a good thing. He was firm with the Office of Public Defender, and he was insisting that the public defenders were telling lies, were fabricating evidence, and they were basically selling him out to the state attorney's office, and he didn't trust them. The public defender's office, and from Dykes, it's very similar to what's happening to me. In my case, I have a law degree, right? I'm a lawyer. I'm not an attorney, right? I'm not licensed to practice law, but I have a Juris Doctor degree from George Washington University Law School. I have an MBA. I have 5 university degrees. I've studied extensively. I studied at Oxford, did international human rights law. So I understand my rights. I'm an educated man. But Dykes, he wasn't an educated man. He admitted, he said he wasn't intelligent. But this guy knew that, look, the Office of the Public Defender was selling him out. And apparently I see that's a practice of the Office of the Public Defender. They sell out to the state attorney's office. They sabotage defendants if they're indigent, this is or they're minorities. One of the first things they do is, so they use intimidation methods, right? If, they want you to take a plea bargain to make things easy for the state attorney, right? Because the burden of proof is on the state attorney. They file charges, they have to be able to, use evidence to prove beyond a reasonable doubt that the defendant is guilty. But they don't really want to go to trial if they don't have evidence to prove things. So it appears that many of them collude. That was how Dykes saw this, that they were colluding and trying to probably get the Dykes to accept terms that would sabotage him or for him to take a plea, and he refused. And when he refuses, the Office of Public Defender does stuff, and they ask for an incompetency order, right? They ask for a competency evaluation. They have quack doctors who are going to find the defendant incompetent. In fact, there was a guy called a Dr. Lawrence or whatever, a doctor who said he actually had brain damage, right? While 2 other doctors, psychiatrists, had found him competent to stand trial. But the Office of the Public Defender, he first had a female, and her thing was, even though he complained about her, what she was doing, he complained about her being unethical, right? And he has a right to effective counsel, right? But it's the Office of Public Defender is indigent, so all she keeps doing is she keeps requesting that he has a competency evaluation. So obviously that they'll find him incompetent. They even filed a plea that the judge should find the person incompetent. So I see that's what my attorneys, the Office of Public Defender, did with me. They do all these things behind, they sidebar, and they have because the Office of Public Defender is paid for by the states, right? And so it's the state's money, and so even though they're supposed to be, their loyalty is to the defendants, that's not really the case. That's not really what's happening. So hopefully this will get to the things like this will eventually get to the Supreme Court and to Congress. It's a perversion of justice, and it impugns on the constitutional rights of American citizens, on our values, because we have rogue cops who file false charges against people, Americans. And the thing is, one's still innocent until proven guilty. That's our principle. And you have a right to have a public trial. It's a Sixth Amendment protection. You have a right to an impartial jury. You have a right to effective counsel. That's absolute. So this guy, at least he was smart enough to keep insisting that he didn't want this person's counsel, the public defender, because they were sabotaging him. And the public defender, all they kept trying to do was get the guy committed, find him incompetent, right? And when they send you to a psychiatric hospital, some of the doctors, what they want to do is they coerce you. They start giving you medication. They coerce you. You can be there for years. For years, they coerce you to accept what the state is saying, what the state attorney is offering, to accept you to take a plea bargain, because your life it's being in a psychiatric hospital is actually worse than being in jail. At least in jail, you have control of your mind. They take you to a psychiatric hospital. If they force medicate you, or if they do stuff like that, anything to you that force medicate you, they've messed up your mind. They're saying you're not competent. They're saying you don't have your agency. You don't have your dignity and autonomy, and that's in violation of Parren versus State. Parren versus State is saying, well, the accused still has a right to affirm their dignity and autonomy. When judges are finding defendants incompetent to stand trial, when they're doing falsely finding defendants incompetent to stand trial, like Judge Bonifant did to me several times. And on February the 2nd, he was now threatening me with that again because he said I was rigid. All my public defender has tried to do was coerce me to accept an unfavorable plea bargain. She even wanted me to say I would go back to Nigeria and never come back, even though I'm an American citizen, even though there's no evidence that I committed any crime. They can't find me guilty. But she's just doing the bid of the state attorney, right? And so they're selling you out to the state attorney, basically. And I refused. I'm somebody who has a law degree, right? I have a law degree. In that court that I'm being charged, I was a judicial intern there to a very respectable judge who's still there. And so if they're doing it to me, what do they do to indigent clients? And we see that's what was going on in Dykes versus Maryland. But Dykes was insistent. He was firm. He got convicted, right? Because he was forced to represent himself. But he stood firm that no, he's not going to let the Office of the Public Defender represent him, right? He stood firm. Then eventually he was forced, but he kept insisting that no, he does want to represent himself. Eventually on the day of trial, he was forced to represent himself pro se, a man who said he's not intelligent. Obviously, he's going to be convicted. So he was convicted, right? He's not a lawyer. He can't represent himself. He kept telling the judge, but he was saying he didn't want the Office of the Public Defender to represent him. The lawyers, at one time, the woman was struck, and they brought another guy called Gordon, Mr. Gordon, and that guy was doing the same thing. They consistently demonstrate the same pattern, right? They want to coerce you to accept a plea bargain that the state is offering, right? An unfavorable plea bargain saying you're guilty, or maybe you commit yourself to a psychiatric hospital. And that's why the public defender, one of the tricks they use, a ruse they will use, is to ask the judge, right, to order a competency evaluation. They have a doctor who works for the state who will fabricate a report, a doctor's report, and they find you incompetent, and the judge will do it. So those are the things they do, their methods. This guy Dykes was lucky. There was a doctor for the state, right, for the public defender that's claimed that Dykes had a brain damage. Meanwhile, fortunately, though, the state was not in agreement that Dykes was incompetent. So the state had their evaluators, and two said no, this guy's competent to stand trial, and that was what saved him. That they didn't, the judges didn't find him incompetent and just lock him up in a psychiatric hospital. He was very lucky. So I guess Dykes was probably a white guy, even though he was indigent. I don't know, but that's basically what happens, and so he ended up representing himself because he said no, he's not going to let the office of the public defender represent him, but he still he didn't assert clearly and unequivocally that he wanted to represent himself. He didn't do that. His waiver of counsel could not have been construed as being knowing and voluntary, and that's the requirement that rule 4 -215E states that the defendant has to demonstrate their waiver of their right to counsel and to self-represent, to do it, the waiver of their right to counsel knowingly and voluntarily. And so when he went on appeal, even though he was convicted because he was forced to go pro se means he was representing himself. I, as a lawyer, I'm legally trained. In fact, I'm going to just put this out there. At Bocconi University, I was top of the class in criminal law. I was number one, and it's fun. I continued. I watch forensic files. I watch things on criminal law, forensic files, how to gather evidence. I did forensic science in law school. When I was working, even though my title was auditor, I was doing compliance work, contracts. I was, that was actually what I was doing. In the government. One of the things I was doing that is, reviewing contracts, legal documents, legal analysis. So I know how to do legal research. That's I've done that, right? I've worked in a boutique law firm. I've been a judicial intern in the very court that they're charging me, but I will not represent myself in court. Again, Abraham Lincoln is said to have said, the man who represents himself has a fool for a client. And I remember they taught me at George Washington University Law School that the foolish lawyer is the one who represents himself in court. So I will not do that. I know not to do that. I know to have an attorney represent me, but that doesn't mean that I will have an attorney knowingly, unethically sabotage me or perpetrate misconduct and sell me out to the state attorney. No, I will not accept ineffectiveness of counsel just because I don't want to represent myself. At the same time, I haven't voluntarily or knowingly, clearly or unequivocally relinquished my right to counsel. And that was exactly what the judges found on appeal in the case of Dykes versus Maryland. And so they reversed his conviction and said, that the court needed to appoint him counsel, that he still had an absolute right to effective counsel, and they referred him to the inherent authority of the court to appoint him counsel. My name is Olurotimi Osha. I'll stop this video here and I'll do a subsequent video just discussing how Judge Bonifant has deprived me of my right to effective assistance of counsel. Thank you.